Hello viewers, good afternoon. As you know that yesterday I had introduced my law office to you and explained that what sort of services we provide to the clients. Now today my first episode, uh, which I'm going to start today, is that today we will try to understand briefly about the criminal justice system, about the criminal justice. What is criminal justice? What comprises the criminal justice in any country? And how important it is for any civilized nation. Second, we all know that how difficult it is to get the FIR register with the police. We will try to look at it also in reference to the concerned laws, provisions. So, in nutshell, these are the two areas in which I am trying to focus today for the benefit of the general public, so that they could get hold on these two things, which has become very difficult nowadays for any common man to deal with the police. So let's start from the criminal justice. In common parlance, you understand, criminal justice system we refer to, for example, a crime is committed, and when the crime is committed, then FIRs are registered, investigations are done, trials are conducted, and so on so forth. मैं हिंदी में भी थोड़ी कोशिश करूंगा ताकि हम जो जो भी इसको बाद में सुनेंगे तो उनको भी ये अंडरस्टैंड होगा। तो क्रिमिनल जस्टिस हम सिस्टम हम उसको बोलते हैं। एक एग्जांपल के तौर पे मैं आपको बताऊंगा कि अगर कोई क्राइम हो जाता है, किसी ने क्राइम किया है, तो पहला जो काम होता है वो उसकी एफआईआर है, फर्स्ट इंफॉर्मेशन रिपोर्ट जिसको हम बोलते हैं। फिर दूसरा जो काम है, जिसने क्राइम कमिट किया है, पुलिस का काम है कि उसको अरेस्ट किया जाए। फिर प्रॉपर तरीके से उसकी इन्वेस्टिगेशन की जाए केस की, पुलिस के द्वारा या कोई भी इन्वेस्टिगेटिव एजेंसी जो है। उसके बाद ट्रायल जो है, जब ये सारा काम हो जाए तो कोर्ट का काम है उसको ट्रायल करना, उसका ट्रायल करना, देखना कि उसमें क्या सच है और क्या झूठ है, और अकॉर्डिंगली ऑन द basis of mechanism of evidence, the availability of evidence, court decides the case, and either the accused is acquitted, उसको छोड़ दिया जाता है, या accused is convicted, या उसको सजा हो जाती है। तो ये जो सब चीजें जो मैं आपको बता रहा हूँ, all these things together, they constitute the criminal justice system in any nation. और इसका सबसे जो इम्पोर्टेंट एलिमेंट होता है क्रिमिनल जस्टिस सिस्टम का इन एनी सिविलाइज्ड सोसाइटी, वो ये है कि कितनी तेजी से जस्टिस जो है जो विक्टिम्स हैं उनको मिलता है। तो स्पीडी ट्रायल, speedy investigation, speedy trials, these are essential components of any criminal justice. Suppose if there is no speedy trial, it takes years and years and years together, then the case becomes weak. केस जो है वो कमजोर हो जाता है। कैसे हो जाता है कमजोर? बहुत सी चीजें जो है मेमोरी से चली जाती हैं, फेड हो जाती हैं। एविडेंसेस जो होते हैं, विटनेसेस, कभी कभार ऐसा होता है कि दे डाई। तो चलते चलते डिले होते 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 केस जो है कमजोर पड़ जाता है। और ये डिले जो है, it always add to the benefit of the culprit, accused, most of the time. So, therefore, it is very important that the courts should conduct the criminal trials at a faster speed. They have to avoid the speed of a snail. They have to move faster so that justice could be done. इसमें मैं आपको कॉन्स्टिट्यूशनली भी बताऊंगा कि क्रिमिनल जस्टिस सिस्टम में अक्यूज को कितनी प्रोटेक्शंस हैं, जो अरेस्ट किए जाते हैं पर्सन्स उनको कितनी प्रोटेक्शंस हैं। तो इसमें आर्टिकल 20 है, 22 है, 21 जो है वो आपको, आर्टिकल 21 वो आपको प्रोटेक्शन देता है, आपकी लिबर्टीज को प्रोटेक्शन देता है। और ये बोलता है आर्टिकल 21 that right to speedy trial, right to speedy trial is a fundamental right, meaning thereby that you can assert this right. You can say to the court, this is my fundamental right. Therefore, the court should conduct trial at a faster speed. Court should not move slowly, gradually. Court has every power at its disposal to speed up the trials, which perhaps are not being done nowadays. This is why the pendency is there. Pendency becomes only when courts, judicial system moves slowly. The things which could be done in 1 minute is done in 24 hours or 100 hours. The thing which should have been done in 1 minute is done in 100 hours. So this is the court who has to move very fast because it has the infrastructure, the facilities, the power to move faster. Courts can judge that who is attributing the delay to the case. So accordingly, it can move. It all depends upon the presiding officer uh, of the court. So criminal justice system. This is very important. This is the efficient criminal justice system in any country is the hallmark of its civilized society, where the criminal justice systems are efficient. Those societies could be more civilized because efficient criminal justice system creates deterrence in the society. कैसे होता है? लोगों के मन में ये बात होती है कि अगर हम ये काम करेंगे तो हमें सजा मिल सकती है, पनिशमेंट पेनल्टी मिल हो सकती है हमें, तो इट क्रिएट्स deterrence in the society. I will add to it that consistency in efficiency of criminal justice system, it creates better societies, civilized societies. I exemplify it. Recently, you might have seen or read in the newspapers or have seen in the TVs the George Floyd's case, which happened in Minneapolis city of the United States of America, USA. You might have seen that how the policemen so cruelly killed the black man there, and how fast the trial was happened there, and the accused policeman was uh, convicted there. In no time, this happened. It reflects the efficiency of the system there. And such things have impact on the society, on the criminal minds. The persons who possess criminal intents, they get deterred from such efficient systems and starts fearing that it might happen to them also. So such is the impact of efficient criminal justice system. Therefore, in our own country, India, it is very important that the criminal justice system should be made as efficient as in the United States of America or in some other civilized nations. Uh, courts can contribute a lot in this. So this is what the criminal justice system is. Precisely. We can go at length in this, but my motive is, my object is to convey this message that what the criminal justice system of any country is, what it comprises of. So, this is what the criminal justice system is. We will touch this area while we will discuss FIRs. Now we switch to FIRs. FIRs, this is abbreviation. The full form of FIR is First Information Report. Why it is First Information Report? Suppose when the crime happens, when the crime is committed, from some source or on its own, the police gets the information from the informant or from its own source. And when the police get this information that a crime has been committed somewhere, then the criminal law is set into motion. When you try to understand that when the police receives this credible information that crime has committed, then the criminal law is set into motion. Criminal law, it becomes active. Now, what the police does then? There is one provision in Criminal Procedure Code. Rather, there are two provisions under which FIRs can be registered. One is Section 154 of the Criminal Procedure Code, and another is Section 55 of the Criminal Procedure Code. So these are the two sections under which the FIRs can. Now, the basic difference between the two sections is that when the offense is cognizable, then police don't have to move to the court to seek permission, and police on its own can arrest and can take action under Section 154, provided the offense should be cognizable, not cognizable. And under 155, if the offense is non-cognizable, then police cannot act on its own. Police has to move to the magistrate, the concerned magistrate, and has to seek permission to move further. So this is the only difference between the two sections. Now, the most important is Section 154. Many amendments have been made to this section during the Nirbhaya rape case. After the Nirbhaya rape case, many criminal amendments have been moved and inserted in Section 154. I will focus on those amendments also. So this is in nutshell, this is the purpose of FIR, to set the criminal law into motion. Now, the problem which the society feels, the face, that is, it is not that easy to get the FIR registered with the police. People face difficulties in getting the FIRs registered with the police. This is the problem. Law is there, and this is mandatory law. But The problem is police so easily do not register the FIRs. Now, why it happens so? Now, I will divide the society into various segments. For example, our whereby the police may and may not be influenced. Uh, Number one division is there is one segment which is super rich, super wealthy, and they are super influentials also. So far as this segment is concerned of the society, it is not difficult for them. It is for you public to assess what I am trying to convey to you. For this segment of the society, nothing is difficult. Their FIRs may be registered any moment, any time. Now, there is another segment which is below the first segment, that is the only rich class. They are also influentials, resourceful. For them, it is not difficult to get their FIRs registered. There is another segment in our society which is middle level, below the second segment. Middle level segment also feels difficulty in getting the first information report, that is FIR, registered with the police. Now, there is the fourth segment, which is the most vulnerable class of our society, and that is the poor class, the common man. Poor class is also further has many subdivisions, but but as a whole, excuse me, the poor class is the most affected. For them, it is not easy to get their FIR registered with the police. Now, I leave it to you to assess what I have conveyed to you. Why the society feels deprived in getting their FIRs registered. The law is otherwise. Law is mandatory. I tell you one very important thing, that in FIRs, it is just a first information report. The purpose I have told you, to set the criminal law into motion, to make the police active. Therefore, it is sufficient if the victim says that somebody has tortured him or her, or has committed a crime against her or him. Suppose if a woman says that she has been thrown out of her matrimonial home, she was beaten, tortured, her modesty has been tried to raise, it is sufficient for the police to get into action. No new test detail is required to get the FIR registered with the police. Mind it, बहुत कोई ज्यादा डिटेल्स उस वक्त नहीं चाहिए होती. प्राइमा फेशियाई अगर विक्टिम खुद ही जाके कह रहा है कि मेरे साथ ऐसा हुआ है, तो पुलिस शुड गेट इनटू एक्शन इमीडिएटली, इंस्टेंटली, फोर्थ बीट. और ऐसा करने से क्या होगा? ऐसा करने से ये होगा कि जो क्राइम में सीरियसनेस आ सकती है, अगर हम इसको अवॉइड करें, पुलिस अगर इसको अवॉइड करे, तो it could aggravate the situation of crime. और अगर if police acts on the information of the victim, then it means that police can nip the evil in the bud. वो क्राइम वहां पे रुक सकता है for going further. This is why the police has to act swiftly when such reports are being given to them or from any source. It reaches to them. They should act immediately. They should not avoid it, because it could aggravate the situation. The object of the police is to prevent crime, or not to allow it to happen and then prevent. This is why the first information report is very important. If police does not act on that information, then it is negligency on their part. People must know this. This is true. This is fact in our society, that getting FIRs registered with the police is not so easy. Therefore, now what happens when victim goes to the informant, goes to the police and inform that this has happened? Then it is the immediate job of the legal duty of the police to reduce the things into writing. This is legal duty of the officer in charge of the police. Or he himself will reduce the contents into writing, what the informant say, the police, the officer in charge has to reduce, or under his supervision. The information will be, oral information will be reduced into writing. So this is what the FIR is. Then when the FIR is registered, say for example, then a copy must be provided to the informant of that FIR. Now the question rises that when the FIR is not, police does not register the FIR despite the fact that crime has happened, then what is the alternative available to the aggrieved person? I will illustrate it by sharing a screen, by sharing that particular provision with you, so that you could know transparently, apparently, that you can do this if you are aggrieved by the police not registering your FIR. Just grant me a while I will share the screen with you. Now you can see uh, I will convert it into a full screen so that you could clearly see the provision. Now keep an eye on this, what I refer to. Now this is section 154 of the criminal procedure, the latest criminal procedure code with all newly inserted amendments. This is 154 information in cognizable cases. तो मैंने आपको क्रिमिनल जस्टिस सिस्टम में बताया था कि कॉग्निजेबल केसेस वो होते हैं जिसमें पुलिस को कोर्ट से कोई परमिशन लेने की जरूरत नहीं है. कोर्ट कैन द पुलिस कैन एक्ट ऑन इट्स ओन. तो इसमें आप देखिए क्लास 1 जो है, आई विल रीड इट आउट फॉर योर बेनिफिट. Every information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction and be read over to the informant. And every such information, whether given in writing or reduced to writing, as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. First clause is very clear. First clause says that whether the information is given in writing or orally. If it is given in orally, then it is mandatory. The expression used is shall be reduced. It is mandatory on the part of the officer in charge of the police station that it should be reduced to writing. Then it should be signed by the informant, the person who has given the information. Then it should be entered into a book. It's a journal. It's called GD Journal Diary. It should be entered in a book. These three things the police has to do while registering the case. Then there is proviso to this. These are added. These provisos are added after amendments of section 154. Provided that if the information is given by the woman against whom an offence under section 326A, section 326B, section 354, section 354A, section 354B, section 354C, section 354D, section 376 rape, section 376A custodial rapes, 76B, 376C, 376D, then E, or section 509 of the Indian Penal Code is alleged to have been committed or attempted, then such information shall be recorded by a woman police officer or any woman officer. This Provision proviso is very important. It is recently inserted in the provision that suppose these are all the offenses with the woman committed against the woman. Suppose if the offense is alleged under all these sections which are mentioned in the provision, then it is all the way it is mandatory. The police is bound legally to record this information. And while who can record this information? This information can be recorded by a woman police officer or by any woman officer. You understand this? This is very important. Suppose if अगर किसी फीमेल के साथ इन सेक्शंस के अंदर जो भी क्राइम कमिट हुआ है और वो अलेज करती हैं कि दिस हैज हैपेंड और समबडी हैज अटेम्प्टेड, not only committed, but even if it is attempted, she can, वो लेडी फीमेल पुलिस को इंफॉर्मेशन दे सकती है और फिर जब वो इंफॉर्मेशन पुलिस को देती है तो फिर इट बिकम्स मैंडेटरी लीगली that police officer should record that information. And which police officer? The woman police officer, or for that matter, any woman officer. It has different connotation. Woman police officer and any woman officer, other than the police officer. Then it becomes, तब ये बहुत लीगली मैंडेटरी जरूरी हो जाता है पुलिस स्टेशन के लिए कि वो उस औरत की इंफॉर्मेशन को रिकॉर्ड करे और उस पे एक्ट करे. He can't avoid it. He can't act. The police officer can't act negligently. Police officer can't avoid this information. This is, and if he does that, and if it is proved, then he is not absolved from his own legal liability. He will be liable, that police officer will be liable under law if he avoids and do not record this information. Now come to the second proviso. This is second proviso to section 154, inserted after the amendment to criminal law. In the event that the person against whom an officer an offence under section 354, section 354A, this of the Indian Penal Code is alleged to have been committed or attempted, is temporarily or permanently mentally or physically disabled, then such information shall be recorded by a police officer at the residence of the person seeking to report such offence or at a convenient place of such person's choice in the presence of an interpreter or a special educator, as the case may be. Now, this is also very important provision inserted in section 154 by the legislature कि अगर जिसके खिलाफ the victim, if she is physically disabled or temporarily or permanently mentally disabled, तो उस केस में पुलिस ऑफिसर की ड्यूटी बन जाती है कि उसने जो कुछ भी रिकॉर्ड करना है वो उसके रेजिडेंस पे जाकर उसको रिकॉर्ड करे, और यहाँ ऐसे कन्वीनियंट प्लेस के ऊपर जो उस विक्टिम की जो चॉइस है, और whatever he records, that should be done in the presence of interpreter or a special educator, as the case may be. So this is very important. The society must know this. इसी में क्लास बी जो है वो it says the recording of such information shall be videographed. और जो भी इंफॉर्मेशन जो है वो रिकॉर्ड हो रही है, इट शुड बी प्रॉपरली वीडियोग्राफ्ड, so that court could see the efficiency and the authenticity of the information. Perhaps this is the motive, the intent of the legislature, that something fake should not happen. This is the intent. C says the police officer shall get the statement of the person recorded by a judicial magistrate under Clause A of subsection 5A of section 164 as soon as possible. No, giving more potency to the information, to the case. The legislature has inserted this, that if such things have happened, reduced to writing, FIR is registered, videograph is done, then as soon as possible, under 164, the judicial magistrate, they should, under subsection 5A, the police should go to the concerned judicial magistrate and get the statement of the person recorded by a judicial magistrate. So the attempt of the legislature is to wipe out the fakery, the fake sorts of informations or FIRs. This is the attempt which the legislature has made. This section 154 has become so important now for the society. Nothing is left for the police now. According to this, the information which is given to the police officer, then police officer in charge of the police station is duty bound legally to record that information and act in accordance with the procedures as laid down in section 154 of Criminal Procedure Code. Now, this was all about clause 1 and proviso appended to clause 1. Now, second clause of the section says, a copy of the information as recorded under subsection 1 shall be given forthwith free of cost to the informant. Suppose if the information is recorded, FIR is recorded, then copy of that free of cost is mandatorily be given forthwith to the informant. The police cannot say that we will not come next time, we will do this time we don't have time, as police does. They try to avoid provide copies to the it is very difficult. It is very difficult when somebody is on the police station and to get something done from the police. It is not that easy. They do not provide even a piece of paper there, not to talk of this report. A copy of the information as recorded, then forthwith, that means without any delay, the police will provide copy of the information, FIR to the informant. Now, I will draw your attention now for the most important part of this section 154, which none know about it. None in our society, not even a single person know about this. What happens? What is the difficulty? What is the complexity? What is the implication that a person feels when he goes to the police station to get his FIR registered? The difficulty is that they don't register it. The police will try to avert you. That is the problem. And the persons, the victims, has to go from pillar to post to get his or her FIR registered. I have the examples. I am dealing with the cases. Practically, empirically, I am dealing with the cases where police uh, do not register. Even the women's cell, which are meant for the benefits of the welfare of the females, they make them run here and there. I can exemplify. I can cite examples practically. Now, coming to the point, if the person is aggrieved by the act of the police that they are not registering their information, then what is the remedy? What is the solution, legal solution available to a common man, to the aggrieved person who is unable to get his FIR registered with the police? Now, have a look at this class 3 of section 154 criminal procedure code. I will read out for your benefit. Any person aggrieved by a refusal on the part of an officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the superintendent of police concerned, who, if satisfied that such information discloses the commission of a cognizable offence, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him in the manner provided by this code, and such officer shall have all the powers of an officer in charge of the police station in relation to that offence. Now, this is the legal remedy available to you. If officer in charge of the police station, concerned police station, where you have approached for registration of a FIR, यहाँ आपने FIR रजिस्टर करवाने के लिए जिस पुलिस स्टेशन पर आप गए और उसने रिफ्यूज कर दिया, तो फिर आपके पास क्या अल्टरनेटिव रहता है? फिर आपके पास कानून में ये अल्टरनेटिव है कि आपके एरिया का जो कंसर्न सुपरिंटेंडेंट ऑफ पुलिस होगा, यानी कि एसपी, आप वो इंफॉर्मेशन पोस्ट रजिस्ट्री पोस्ट को रजिस्टर बाई पोस्ट रजिस्टर्ड पोस्ट आप उस ऑफिसर को, एसपी को, सुपरिंटेंडेंट ऑफ पुलिस को भेज सकते हैं। और जब वो पुलिस ऑफिसर एसपी जो है वो उस इंफॉर्मेशन को देखता है और वो पाता है कि ये जो इंफॉर्मेशन है ये कॉग्निजेबल ऑफेंस डिस्क्लोज कर रही है, इससे लग रहा है कि ऑफेंस जो है, कॉग्निजेबल ऑफेंस जो है वो कमिट हुआ है, तो वो या तो वो क्या करेगा, वो या तो अपने आप उसको इन्वेस्टिगेट करेगा या जो उसका पुलिस ऑफिसर, सबऑर्डिनेट पुलिस ऑफिसर होगा, उसको जो है वो इन्वेस्टिगेशन के लिए वो दे देगा। तो वो आपकी जो FIR है वो रजिस्टर जो है इस तरीके से हो जाएगी। नाउ क्लास 3 is very important and this is a solution to the aggrieved person who is unable to get his FIR or her FIR registered with the concerned police station of the offence, cognizable offence which has been committed, alleged to have been committed against him or her. This way, the information which she or he wanted to give it to the concerned police station could give the same to the concerned SP, Superintendent of Police, in writing by post. It has to be given by post. So better is you get your this post registered, keep the receipt with you for future reference. Then on receipt of this information by the SP either if he finds that cognizable offense has been committed, then either he will take the investigation himself or he will direct any police officer subordinate to him to investigate the matter. This way, this provision give you the resolution. This is what the section 154 is. You keep in mind two things, that you go to the police station and for registration of FIR, but it is not registered, you become aggrieved. Then what is the resolution? Resolution is then you have to approach to the concerned superintendent of police. It may be SP and it may be SSP of the concerned area. First thing you have to do is to register by post the information to the concerned SP as well as the SSP. To both, keep the receipts of the registry in your custody for the future reference. don't lose it. Uh, then, uh, if the police station, the SP or SSP finds that this is cognizable offense and it is to be investigated, then they do it. They don't avoid it then, because they are responsible officers. Uh, but say, for example, despite this, nothing is done. Then what is the alternative left with you? Then you have the only alternative. You have seen, otherwise you have follow the system, the criminal justice, the criminal law, but nothing is done. No relief is there to you by the executive side. Then the last resort which you have is the court. Then you have to move to the court to get your FIR registered with the concerned police station. Now, if you do that, there are two ways to do this, to get seek resolution from the judicial courts. There is one section 156, subclass 3. Your counsel will move your case through that section to the concerned chief judicial magistrate of the area. Then he will direct the police station, the concerned police station, to register that. That is one. The second is, you can file full-fledged complaint before the criminal court under section 190 of Criminal Procedure Code. Then you don't move to here and there. Then the court will investigate, inquire the matter on its own. Court will, if court finds, if court take cognizance of your complaint, then court issues summons or warrants to the accused, and the trial starts. So the ultimate resort is court. If you fail to get justice from the executive, then the last resort is the court. Then court take care of your grievances. So this is all about the. I will stop the sharing. This is concluding. This is all about what is criminal justice system, what constitutes the criminal justice, what is FIR, what steps you will take if FIR is not registered by the police, and ultimately, if you fail in all forums of the executive, then what is the last resolution, legal resolution available with you? I have explained to you in a very simple manner, just to convey the message that don't get disheartened when FIR is not registered and crime is committed against you, alleged to have been committed against you. You follow these procedures, follow these steps, and if you fail on the first